Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's video, we are going to discuss section number 104 to 120 of Bharatiya Sakshya Adhiniyam 2023.
Hello students and a very warm welcome to Ganga Education. Today, we're going to tackle a very important topic in evidence law that is absolutely crucial for your judiciary and APO exams, section 104, the burden of proof. Let's get started.
So, let's kick things off with a simple question. In any court case, when a fact is presented, who is actually responsible for proving it? It's something to think about, isn't it? Well, the answer to this very basic question is found in Section 104 of the Indian Evidence Act.
To properly understand any law, the very first thing we should do is look at the bare act itself to understand its exact wording. So let's see what Section 104 actually says. In simple language, what this means is that if you want a court to give a decision in your favor on your side, then you have to prove your claim, your facts. For instance, if you say that your friend borrowed money from you, the responsibility to prove it is on you, not your friend. The simple rule is this: he who asserts must prove. Whoever makes the claim must also provide the proof.
Every legal section has some essential ingredients which are very important to understand, especially for writing answers in your mains exam. Let's take a look at what those essential ingredients are for Section 104.
In this slide, you can see that Section 104 has four main building blocks. First, the assertion of fact. That's when a party makes a positive claim before the court. Second, legal right or liability, meaning that claim must be related to a legal right or liability. Third, dependence on facts, which means whatever judgment the court gives will depend on the proof of the facts you've provided. And fourth, arising from all of this, is the duty to prove, meaning the one who makes the claim has the duty to prove it.
And this slide illustrates the practical process in court very well. It's a logical chain. You see, first the party asserts a fact, then claims a legal right based on that fact. As soon as they do that, the burden of proof automatically falls on that same party, and only when they provide that proof can the court give a judgment in their favor. It's a very simple and logical process.
Theory is fine, but to understand law in the real world, practical examples are essential, especially for your exams. Let's look at an exam-oriented scenario that will make Section 104 even clearer.
In this situation, A claims that B signed a promissory note, but B flatly denies it. So who has the burden of proof? According to Section 104, since A made the claim, since A asserted that the signature belongs to B, then A must prove that the signature is indeed B's, perhaps with a handwriting expert or a witness.
Now we come to a very important part. For mains exams, theory alone is not enough. You must also know important case laws. Supreme Court judgments give us the correct interpretation of the law and really help in scoring high marks.
This is a landmark judgment. In it, the court clarified that the initial burden of proof always rests on the party making the positive claim, and this burden only shifts when that party establishes a prima facie case. Now, what is prima facie? It means on the face of it. In other words, when A has presented enough initial evidence that the court, at first glance, feels there is some substance to A's claim. Until then, the burden does not shift.
This distinction is extremely important for your exams. The case of Rangamal versus Kupaswamy explained the difference between two types of burdens. The first is the legal burden, which is the responsibility to prove the entire case. This is fixed, and it generally rests on the person who files the case. It never shifts. The second is the evidential burden, which is the burden to prove a specific fact. This can shift from one party to another during the trial. As soon as one party provides some evidence, the other party has to provide evidence to rebut it.
This case makes the fundamental rule of Section 104 even stronger. It reaffirms that whoever asserts a fact to claim a legal right has the burden of proof. This is an important pillar of our evidence law.
Laws like Section 104 didn't just appear suddenly. Behind them are some timeless principles of justice, which we call legal maxims, that form their foundation. Let's see what the philosophical foundation of this rule is.
This Latin maxim is the classical version of Section 104. It means that the burden of proof is on the person who claims something, not on the one who denies it. And what's the logic behind this? The logic is that it's easier to prove the existence of something than to prove its non-existence. Therefore, the person who makes the positive claim has the responsibility to prove it.
This second maxim is similar to the first one, but it applies specifically to civil cases. It means the burden of proof is on the plaintiff. Who's the plaintiff? The plaintiff is the person who files the case, the one who knocks on the court's door. If you bring a case to court, you have to prove it. You can't just file a case and expect the other party to disprove your allegations.
All right, students, let's now focus on the most important part of your preparation. This final section will help you score high marks on questions related to Section 104, so please listen carefully.
You should definitely note these points. For the prelims, you might be asked a direct question like, which section deals with the general rule of burden of proof? The answer is Section 104. Simple. For the mains, a problem-based question like the promissory note example we discussed could come up, or you might be asked to write a short note on the difference between legal and evidential burden, in which you must, absolutely must, cite the Rangamal case. So, for a quick revision of this entire topic, we can summarize it in these 3 points. First, the section number is 104. Second, the core concept is he who asserts must prove. And third, the key case is Rangama versus Kupuswamy, which explained the important difference between legal and evidential burden. The exam importance of this section is very high because it's a fundamental principle, without which evidence law is incomplete.
So that was our explainer on Section 104. I hope you understood everything well. For more such high-quality legal content for judiciary, APO, and other law exams, stay connected with Ganga Education.
Today, we're diving into a really practical and super important topic from the Indian Evidence Act of 1872, Section 105, which is all about the burden of proof. Trust me, if you're gearing up for the judiciary or APO exams, this is one section you really need to know inside and out. So, here's our game plan for today. We'll start by understanding this section itself, break it down, look at some real cases, touch upon the principles behind it, and then wrap up with a sharp focus on what you need for your exams. This way, we'll make sure you have complete clarity. Let's get started. All right, first up, let's get to the heart of Section 105. Think of this section as providing a very simple, almost common sense test to figure out who has the job of proving a fact in court. Now, that's the exact wording from the law, but what does it actually mean? Well, in simple terms, the court asks a hypothetical question. What if nobody presented any evidence at all? Who would lose the case right now? The person who would lose, that's the person who has the burden of proof. It's a pretty neat concept, and we call it the failure test. Okay, to really master this section, we're going to break it down into its core ingredients. Once you see these building blocks, the whole idea behind Section 105 will just click into place. So we've got 3 key elements here. First, there has to be an existence of a suit, basically a live legal case happening. Second, the court applies the absence of evidence test. It just imagines a scenario where both sides have presented zero proof. And third, and this is the most important part, is the failure test. The party that would lose in that no evidence world is the one carrying the burden. It's that simple. This chart here really shows you the failure test in action. It's a 3-step mental exercise. Step 1, the court pictures a courtroom with absolutely no evidence. Step 2, it asks itself, all right, based on just the claims, who loses right now? And step 3, whoever that losing party is, bam, they get the burden of proof. This is exactly how it works. Okay, so we've got the theory down, but how does this play out in the real world? Let's take a look at how the Supreme Court has actually used and interpreted this section in some major cases. This is where it gets really practical. You're probably thinking, okay, that sounds straightforward, but how does this really work in a proper courtroom setting? Before we jump into the landmark judgments, let's walk through a very basic, practical example. Let's imagine this scenario. A sues B to get back a 50,000 rupee loan. B comes to court and says, I never took any loan from him. Now let's apply our failure test. If neither A nor B brings any evidence, no papers, no witnesses, nothing, who loses? A does, right? His case would get thrown out. Therefore, the burden to prove that the loan was actually given is on A. And this isn't just theory. It's backed by the Supreme Court. In the landmark case of Anil Rishi versus Gurbakh Singh, the court said exactly this. The burden of proof is on the party who is making the positive claim, the one who is asserting something. In our example, A was asserting he gave a loan. The court also confirmed that the failure test from Section 105 is the main way to figure this out. Now, let's switch over to criminal law, because there's a vital difference here. In the case of Kali Ram versus the state of HP, the Supreme Court made it crystal clear. Because of the presumption of innocence, if no evidence is given in a criminal trial, the accused has to be acquitted. And what does that mean? It means the burden of proof always starts with the prosecution. You know, behind almost every rule in law, there is a deeper principle, often an ancient one. Let's look at the legal maxim that forms the foundation of Section 105, and we'll also see where this concept stands in our new legal framework. This whole idea is beautifully captured in a Latin maxim. It sounds complicated, but the meaning is very simple. E incumbit probatio qui dicit, non qui negit. All it means is that the burden of proving a fact rests on the person who asserts it, not on the person who denies it. He who alleges must prove. That's the soul of Section 105. Now, this is super important for all you aspirants. You need to know how this fits with the new laws. Well, Section 105 of the old Evidence Act now corresponds to Section 109 of the Bharatiya Sakshya Adhiniyam 2023. The number has changed, but the core concept, the failure test, is exactly the same. So all the knowledge you're gaining today is perfectly relevant. Okay, let's get down to brass tacks, the exam focus. This is where we distill everything we've learned into the key points you absolutely need to remember for your judiciary and APO exams. So, for your prelims, expect a direct question. They might ask for the section number or which section deals with the failure test. For the mains, it's more likely to be part of a problem-based question. And remember, this applies to both civil and criminal cases. But here's a crucial tip. Section 105 determines the initial burden. This burden can, and often does, shift during the trial once evidence starts coming in. That's a key concept. All right, time for a super fast revision. When you're in that exam hall, just remember these 3 things. 1, the section number, 105. 2, the core idea, the failure test. And 3, its application, on the plaintiff in civil cases and on the prosecution in criminal cases. Got it? And before we wrap up, I want to leave you with a little food for thought. We talked about the initial burden set by Section 105. So how does that initial burden interact with the idea of a shifting burden of proof during a trial? Thinking about that connection will really elevate your answers, especially in the mains exam. For more in-depth legal content designed specifically for judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Today, we're diving into a really crucial section of the Bharatiya Sakshya Adhiniyam 2023. All right, so our focus for today is Section 106. Now, this section is part of the Burden of Proof chapter, and it's all about who has the responsibility to prove a very specific fact. And let me tell you, for anyone preparing for judiciary or AOP exams, this section is absolutely essential. So, here's how we're going to break it down. First, we'll get a grip on the core rule. Then we'll deconstruct it into its essential parts. After that, we'll look at how it's actually applied in court, explore the legal maxim behind it, and finally wrap up with some key points specifically for your exams. Okay, let's kick things off with the core rule. What does the BEAR Act actually say? Let's take a look at the precise wording. So what does that actually mean in simple terms? Well, it's pretty straightforward. If you want the court to believe that a specific fact, a particular fact is true, then the responsibility, the burden, to prove it, well, that's on you. There is a catch, though. This rule has an exception. If another law specifically says something different, then that other law will take precedence. To really understand this section inside and out, let's break it down into its essential ingredients. This will make it much clearer. You can think of this section as having 4 key building blocks. First up, we have particular fact. That's any specific, individual fact relevant to the case. Second, wishes the court to believe. This just means one party wants the court to accept their fact as true. Third, burden on that person. Clearly stating the duty to prove falls on them. And finally, that all-important exception, unless provided by any law. Okay, so we've covered the theory, but how does this all play out in a real courtroom? Let's move from theory to practice and see this section in action. So yeah, how does this actually work when you're in a courtroom? Let's take a classic practical example, the alibi defense. Imagine the prosecution presents evidence to show the accused committed a crime. Now, the accused claims, "It wasn't me. I was in a completely different city that day." You see, that alibi is a particular fact that is especially within the accused's own knowledge. So Section 106 kicks in, and the burden now shifts to the accused to prove their alibi. But, and this is a crucial point, this does not mean the prosecution's main burden to prove the crime itself just disappears. That still rests with the prosecution. Now, let's look at some landmark case laws. It's always important to see how the Supreme Court and various high courts have interpreted this section over the years. First up, we have State of Rajasthan versus Kashi Ram. In this case, the court made it crystal clear. If a fact is especially within a person's knowledge, the burden to prove it is on that person. And if they fail to explain it, the court can then draw what's called an adverse inference against them, basically assuming the worst. Next, let's look at Shambhu Nath Mehra versus the State of Ajmer. This case is key because it clarified that Section 106 isn't the general rule, it's an exception. It only applies when a fact is especially within the knowledge of one particular party. This distinction is really important to remember. You know, every legal rule has a foundational principle behind it. So let's dig a little deeper and see what legal maxim forms the basis for Section 106. The maxim is this: E incumbit probatio, qui dicit, non qui negit. Now, what does this Latin phrase mean? It translates to a very logical idea. The burden of proof lies on the one who asserts, not on the one who denies. In other words, the person making a claim is the one who has to prove it. And this principle is the very heart of Section 106. Now, for all the aspirants out there, this is a very important point. This provision isn't new. It was previously Section 106 of the Indian Evidence Act of 1872. In the new Bharatiya Sakshya Adhiniyam, it has been retained as Section 106. The core legal provision remains exactly the same, so no changes there. So what happens if a party fails to meet this burden of proof? Well, three things. First, the court will consider that fact not proven. Second, as we saw in the Kashi Ram case, the court might draw an adverse inference. And third, and most importantly, this failure can significantly weaken their entire case. All right, let's get to the final and perhaps most crucial part for you all, the exam focus. Let's break down exactly what you need to remember for your judiciary and APO exams. Okay, make a note of these tips. For the prelims, expect direct questions on the section number or its core principle. The legal maxim is also a hot topic for MCQs. For your mains, be ready to write a short note on the scope of Section 106 with case laws. You could also get a problem-based question centered on the concept of a fact being especially within the knowledge, so prepare for that. Let's do a quick fire revision. 3 things you absolutely must remember. First, the section number, Section 106. Second, the core concept. The burden to prove a particular fact is on the person who asserts it. And third, the key principle. It applies to facts that are especially within the knowledge of a person. And remember, its importance for exams is very, very high. For more legal content focused specifically on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
आज हम एविडेंस लॉ का एक बहुत ही फाउंडेशनल प्रिंसिपल डिस्कस करेंगे। आप कह सकते हैं कि ये एक गेटकीपर की तरह काम करता है जो डिसाइड करता है कि कोर्ट कौन सा एविडेंस सुनेगा और कौन सा नहीं। तो आज हम डिस्कस करेंगे सेक्शन 107 ऑफ द इंडियन एविडेंस एक्ट 1872। ये सेक्शन बर्डन ऑफ प्रूफ चैप्टर का हिस्सा है। बेसिकली ये सेक्शन एक बहुत ज़रूरी सवाल का जवाब देता है। किसी भी एविडेंस को एडमिसिबल मानने से पहले किसकी जिम्मेदारी है कुछ प्रूव करने की। जुडिशरी और एपीओ एग्जाम्स के लिए ये सेक्शन काफ़ी इंपॉर्टेंट है, इसलिए ध्यान से समझिएगा। चलिए देखते हैं आज हम क्या क्या कवर करेंगे। पहले हम सेक्शन 107 का एक इंट्रोडक्शन लेंगे, फिर इसके कोर इंग्रेडिएंट्स को समझेंगे, उसके बाद देखेंगे कि कोर्ट में इसका एप्लीकेशन कैसे होता है, फिर हम गाइडिंग लीगल प्रिंसिपल्स पर बात करेंगे और एंड में एग्जाम्स के पर्सपेक्टिव से इस टॉपिक को देखेंगे। ओके, तो शुरू करते हैं। देखिए, सेक्शन 107 एक बहुत सिंपल लेकिन पावरफुल आइडिया पर बेस्ड है। जैसे आप बिना फाउंडेशन के घर नहीं बना सकते, वैसे ही आप एक लीगल आर्ग्यूमेंट उस एविडेंस पर नहीं बना सकते जिसका फाउंडेशन ही प्रूव ना हुआ हो। ये रूल इसलिए बनाया गया है ताकि कोर्ट का टाइम अनरिलायबल या इररेलेवेंट इन्फॉर्मेशन पर वेस्ट ना हो। ये है सेक्शन की एग्जैक्ट वर्डिंग। थोड़ी डेंस लग सकती है, बट सिंपल लैंग्वेज में समझें तो इसका मतलब ये है कि अगर आप कोर्ट में कोई मेन एविडेंस मानते हैं फैक्ट बी पेश करना चाहते हैं, लेकिन उसको पेश करने के लिए पहले एक और फैक्ट ए को प्रूव करना जरूरी है, तो उस फैक्ट ए को प्रूव करने की जिम्मेदारी यानी बर्डन ऑफ प्रूफ आप पर ही होगी।
तो चलिए अब इस सेक्शन के कोर इंग्रेडिएंट्स को ब्रेक डाउन करते हैं। आप इन्हें सेक्शन 107 के बिल्डिंग ब्लॉक्स की तरह सोच सकते हैं।
इस सेक्शन में बेसिकली ये 4 इंपॉर्टेंट एलिमेंट्स हैं। फर्स्ट, फाउंडेशनल फैक्ट। ये वो प्रिलिमिनरी फैक्ट है जिसे पहले प्रूव करना पड़ता है। सेकंड, पर्पस ऑफ एडमिसिबिलिटी, मतलब ये फाउंडेशनल फैक्ट जरूरी है ताकि आपका दूसरा एविडेंस लीगली एक्सेप्टेबल हो। थर्ड, बर्डन ऑफ प्रूफ। जैसा हमने देखा, ये जिम्मेदारी उसी पर्सन पर है जो एविडेंस दे रहा है। और सबसे इंपॉर्टेंट, फोर्थ, कंडीशन प्रीसीडेंट। इसका मतलब है कि जब तक फाउंडेशन प्रूव नहीं होता, मेरा एविडेंस एडमिट ही नहीं किया जाएगा। ये फ्लोचार्ट कोर्ट के लॉजिकल सीक्वेंस को दिखाता है। देखिए, प्रोसेस शुरू होता है जब कोई पार्टी अपना मेन एविडेंस सबमिट करना चाहती है, लेकिन सेकेंड स्टेप एक मैंडेटरी प्रीरेक्विजिट है। एक फाउंडेशनल फैक्ट पहले प्रूव करना होगा। थर्ड, उस फैक्ट को प्रूव करने का बर्डन उसी पार्टी पर है। और सिर्फ उसके बाद जब फाउंडेशन एस्टैब्लिश हो जाता है, तभी मेन एविडेंस एडमिसिबल माना जाता है। तो ये सब थ्योरी में तो ठीक है, बट एक्चुअल कोर्टरूम में ये कैसे काम करता है? चलिए अब थ्योरी से प्रैक्टिस की तरफ चलते हैं और कुछ रियल एग्जाम्पल्स से सेक्शन 107 को एक्शन में देखते हैं। एविडेंस एक्ट खुद एक क्लासिक एग्जाम्पल देता है, डाइंग डेक्लेरेशन। मान लीजिए पार्टी ए को बी का डाइंग डेक्लेरेशन प्रूव करना है, तो सेक्शन 107 के हिसाब से ए को पहले फाउंडेशनल फैक्ट प्रूव करना होगा कि बी की डेथ हो चुकी है। सिर्फ उसके बाद ही बी के स्टेटमेंट को एज ए डाइंग डेक्लेरेशन एडमिट किया जा सकता है।
एक और स्टैट्यूटरी इलस्ट्रेशन है सेकेंडरी एविडेंस का। सोच के देखिए, ए एक गुम हुए डॉक्यूमेंट के कंटेंट्स को एक फोटोकॉपी से प्रूफ करना चाहता है, तो कोर्ट उस फोटोकॉपी को देखने से पहले ही ए से कहेगा कि पहले ये फाउंडेशनल फैक्ट प्रूफ करो कि ओरिजिनल डॉक्यूमेंट सच में खो गया है या डिस्ट्रॉय हो गया है। इस प्रूफ के बिना वो कॉपी इनएडमिसिबल होगी। और ये मत सोचिए कि ये कोई पुराना रूल है, आज भी ये बहुत रेलेवेंट है। फॉर एग्जाम्पल, सीसीटीवी फुटेज। अगर प्रोसिक्यूशन किसी वीडियो क्लिप पर रिलाई करना चाहती है, तो उन्हें पहले कुछ फाउंडेशनल फैक्ट्स एस्टैब्लिश करने होंगे, जैसे पहला कि उस टाइम कैमरा ठीक से काम कर रहा था, और दूसरा कि फुटेज ऑथेंटिक है और उसके साथ कोई टैंपरिंग नहीं हुई है। आज के इलेक्ट्रॉनिक एविडेंस के दौर में ये और भी ज्यादा क्रिटिकल हो गया है। मान लीजिए कोई पार्टी व्हाट्सएप मैसेजेस सबमिट करना चाहती है, वो सीधे जज को फोन नहीं दिखा सकते। पहले उन्हें फाउंडेशनल फैक्ट्स प्रूव करने होंगे, जैसे फोन नंबर या अकाउंट की ओनरशिप, और ये भी एस्टैब्लिश करना होगा कि चैट लॉग इलेक्ट्रॉनिक एविडेंस के रूल्स के अंडर ऑथेंटिक है। अब आगे बढ़ते हैं और कुछ लीगल प्रिंसिपल्स और लैंडमार्क जजमेंट्स देखते हैं जिन्होंने सेक्शन 107 की अंडरस्टैंडिंग को शेप किया है। इस पूरे प्रिंसिपल को एक लीगल मैक्सिम बहुत अच्छे से समझाता है, सुब्लाटो फाउंडेशनो कार्डेट ओपोस। इसका मतलब है जब फाउंडेशन ही हटा दिया जाए तो स्ट्रक्चर गिर जाता है। एविडेंस के कॉन्टेक्स्ट में अगर आप अपना फाउंडेशनल फैक्ट प्रूव नहीं कर पाते, तो आपका मेन एविडेंस जो उसी फाउंडेशन पर टिका था ऑटोमेटिकली कोलैप्स हो जाता है। एक बहुत ही लैंडमार्क जजमेंट जो इस प्रिंसिपल को अप्लाई करता है वो है हरपाल सिंह वर्सेस स्टेट ऑफ हिमाचल प्रदेश। इस केस में मेन इशू सेकेंडरी एविडेंस की एडमिसिबिलिटी का था। कोर्ट ने ये होल्ड किया कि एक फोटोकॉपी यानी सेकेंडरी एविडेंस सिर्फ और सिर्फ तभी एडमिसिबल होगी जब पहले ये प्रूफ कर दिया जाए कि ओरिजिनल डॉक्यूमेंट खो गया है या डिस्ट्रॉय हो चुका है। ये रूलिंग उस कंडीशन प्रेसिडेंट के रूल को स्ट्रांगली रीएनफोर्स करती है। सिंपल, नो फाउंडेशन, नो एविडेंस। और अब आते हैं सबसे इंपॉर्टेंट पार्ट पर, स्पेशली आपके एग्जाम्स के लिए। जुडिशरी और एपीओ एग्जाम्स के पर्सपेक्टिव से सेक्शन 107 को कैसे अप्रोच करें, चलिए देखते हैं। जुडिशरी प्रीलिम्स में आपको डायरेक्ट क्वेश्चन मिल सकता है, या तो सेक्शन नंबर पर या इसकी कोर प्रिंसिपल पर। मेंस में प्रॉब्लम बेस्ड क्वेश्चन आने के चांसेस ज्यादा हैं, जहां आपको एक सिचुएशन देकर सेक्शन 107 अप्लाई करने को कहा जाएगा। इसके अलावा कंडीशन प्रेसिडेंट फॉर एडमिसिबिलिटी ऑफ एविडेंस पर शॉर्ट नोट लिखने के लिए भी आ सकता है, तो उसके लिए भी तैयार रहिएगा। तो क्विक रिविजन के लिए ये 3 चीजें हमेशा याद रखिए। पहला, सेक्शन नंबर 107। दूसरा, इसका कोर कॉन्सेप्ट, फाउंडेशनल फैक्ट्स मस्ट बी प्रूवन फर्स्ट। और तीसरा, की प्रिंसिपल, नो फाउंडेशन, नो एविडेंस। और हाँ, प्रीलिम्स और मेंस दोनों के लिए इसकी इंपॉर्टेंस बहुत हाई है। जाते जाते मैं आपके लिए एक सवाल छोड़ रहा हूँ।
अगर फाउंडेशन ही सबसे ज़रूरी है, तो कोर्ट ये कैसे डिसाइड करता है कि कौन सा फाउंडेशन स्ट्रांग इनफ है और कौन सा नहीं? इस पर ज़रूर सोचिए, इससे आपकी अंडरस्टैंडिंग और भी गहरी होगी। तो ये था हमारा आज का एक्सप्लेनर। जुडिशरी, एपीओ और दूसरे लॉ एग्जाम्स पर ऐसे ही फोकस्ड कंटेंट के लिए गंगा एजुकेशन के साथ जुड़े रहिए।
So today we're going to tackle a really interesting and important section. Section 108 of the Bharatiya Sanhita 2023. This section deals with a fundamental principle of criminal law, which is the burden of proof. More specifically, it addresses what happens when an accused person claims an exception as their defense. You know, this is a super important topic for your judiciary and APO exams. So let's get right into it and break it all down.
So here's how we're going to approach this. First, we'll look at the core legal problem that Section 108 is designed to solve. Then we're going to deconstruct the actual language of the section itself. After that, we'll see how it works in the real world with some practical examples and landmark cases. We'll also quickly compare the old law with the new one. And finally, we'll wrap it all up with a very exam-focused revision. All right, let's start with the fundamental question. You know, there's a golden rule in criminal law. Innocent until proven guilty, right? This means the burden of proving that the accused is guilty always falls on the prosecution. But what happens when the accused person actually admits to doing the act, but then offers an excuse or a defense to justify it? That's where things get tricky. Just imagine a murder trial for a second. The accused stands up and says, yes, I did commit the act, but I did it in self-defense. Now here's the big question. Who has to prove this claim of self-defense? Does the prosecution have to prove that it wasn't self-defense, or does the accused have to prove that it was? This is the core problem we're talking about today.
And this is exactly where Section 108 comes in and gives us a crystal clear answer. What this section does is create a very logical legal shift. It says that if an accused person wants to bring their case under any general or special exception, then the burden of proving the facts for that exception, well, that burden falls squarely on the accused. And it makes sense, right? Because the accused is the one who has special knowledge of those circumstances. Okay, let's move on to our second part. Now we're going to really dig into the precise language of Section 108 to understand all of its essential components.
The wording here is so precise. It really has two very important parts. First, it states clearly that the burden of proving an exception is upon him, meaning the accused. And second, it says the court shall presume that no such exceptional circumstances exist unless the accused can prove that they do. So the starting point for the court is that there's no exception. So we can break this section down into four essential ingredients. 1. There has to be an accusation of an offense. 2. The accused must actually plead an exception, like insanity or private defense. 3. The burden to prove that exception is on the accused. And 4. The court will always start with the presumption of absence of such circumstances. It's a complete package.
You know, this principle in Section 108 is actually based on a foundational concept in law, which is perfectly captured by the Latin maxim, e incumbent probatio qui dicit. It sounds complicated, but it has a very simple meaning. The burden of proof lies on the one who asserts a fact. And in this case, since it's the accused who is asserting the facts of an exception, the burden to prove them is also on him. Simple as that.
Now this is a critically important point, especially for your exams, so pay close attention. The standard of proof is different for the prosecution and the accused. The prosecution has to prove its case beyond a reasonable doubt, which is a very high standard. But the accused only has to prove their exception on a preponderance of probabilities. This is a much lower standard. It just means they have to show that their version of events is more likely to be true than not.
Okay, so we've covered the theory. Now let's see how this all works in practice. We'll look at a few examples and some landmark judgments to make the whole concept absolutely clear. Let's think about a few scenarios. So if an accused pleads self-defense, they have to prove that there was a genuine threat and that the force they used was only what was necessary. If the plea is insanity, the accused needs to bring evidence, like medical records or expert testimony, to prove they were of unsound mind at that time. And if they're claiming grave and sudden provocation, they have to prove that the provocation was so intense and so sudden that they completely lost their self-control.
All right, let's turn to a landmark case now. Dayabai Chaganbai Thakur versus the state of Gujarat. This judgment is incredibly important when we talk about the plea of insanity.
In this landmark judgment, the Supreme Court made it absolutely clear that the burden to prove a plea of insanity is on the accused.
But, and this is the key part, the court also held that the standard of proof for the accused is just preponderance of probabilities, not beyond a reasonable doubt like it is for the prosecution. This case perfectly illustrates that difference in standards we just talked about.
And there's another very significant case, K.M. Nanavati versus State of Maharashtra, which is famous for its discussion on the exception of grave and sudden provocation.
In this case, the court looked very closely at all the evidence that the accused presented. The main issue was whether the accused had successfully proven the necessary circumstances to bring his case under the exception of grave and sudden provocation. You see, the underlying principle was exactly the same. The burden to prove the exception was on the accused.
All right, let's quickly put this provision into context by comparing its place in the new law versus the old one. Understanding this context is really helpful for a complete analysis.
So it's really important to note that this legal principle isn't actually new. It used to be in Section 105 of the Indian Evidence Act of 1872, and it worked together with the exceptions listed in the Indian Penal Code. What the Bharatiya Sakshya has done now is just incorporate this same rule into its own framework under Section 108. So the principle is the same, just its statutory address has changed.
Okay, now let's focus on the most important part for you guys. What kind of questions can you expect from this section in your judiciary and APO exams?
For your preliminary exams, you're likely to get a direct question on the section number or its core principle, something like, who bears the burden of proving general exceptions? For the mains exam, be ready for a problem-based question where you'll be given a set of facts and you'll have to apply Section 108. Also, a short note on the burden of proof on the accused is a very common and potential question.
And now it's time for a super quick revision. First things first, memorize the section number, Section 108.
The core concept is totally straightforward. If an accused person claims an exception, the responsibility to prove that exception is also theirs. That's it. So for a quick revision, just remember these 4 key points. The section is 108 of the BNS. The core concept, the burden of proving exceptions is on the accused. The standard of proof for them is preponderance of probabilities. And a key case to remember is Dayabai Choganbai Thakur. These points are the most critical takeaways for your examination. And that was our detailed analysis of Section 108 of the Bharatiya Sakshya Adhiniyam. We really hope its principles and applications are now perfectly clear to you. For more judiciary, APO, and other law exam-focused content, please stay connected with us here at Ganga Education.
Today, we're going to break down a fascinating legal principle that's all about fairness and common sense. So let me start with a question for you. Imagine there's a piece of information, a fact, that only one person could possibly know. In a court of law, whose job should it be to prove it? This very simple question is right at the heart of what we're going to discuss today. Okay, let's get right into it. Today, we are discussing Section 109 of the Bharatiya Sakshya Adhiniyam 2023. And let me tell you, this section is a real powerhouse within the chapter on burden of proof. So, what does the BEAR Act actually say? It states, when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. In really simple terms, it means that if a particular fact is in someone's special or exclusive knowledge, then the burden, the responsibility, to prove that fact is on that person. Now, this is a brilliant exception to the general rule we all know, which says the burden of proof is usually on the prosecution. To really get this, we need to look at the key words. There are 3 important ideas here. First, the phrase, especially within the knowledge. This means the information is unique to that person, something the other party can't easily access. Second, burden of proving that fact. That's just the legal way of saying it's their job to provide the proof. And third, remember that this is an exception to the general rule, which is what makes our justice system so practical. Let's use a classic practical example to understand this. Suppose a ticket checker accuses you of traveling on a train without a ticket. Now, think about it. Whether or not you actually have a ticket is a fact that is in your special knowledge, right? It's in your wallet or on your phone. It would be nearly impossible for the railway to prove that you didn't buy a ticket. So under Section 109, the burden shifts to you. You just have to show your ticket. See? It's a perfect illustration of how this works in real life. Now, how has the Supreme Court interpreted this principle? This brings us to the landmark case of Shambhunath Mehra versus the state of Ajmer. In this case, the Supreme Court provided a very crucial clarification. The court said that this section only applies when a fact is especially within the accused's knowledge. But, and this is the most important part, this does not mean the prosecution's primary duty to prove the case beyond a reasonable doubt just goes away. So this section is a supplementary rule, not a replacement for the prosecution's fundamental responsibilities. Now for a quick but really important comparison between the old and new laws. This very same rule used to be Section 106 of the old Indian Evidence Act, 1872. Now, under the new Bharatiya Sakshya Adhiniyam 2023, it has become Section 109. The core concept is exactly the same, but the section number has been updated. Please make a special note of this for your exams. All right, now for the most critical part. Why is this so important for your exams? Well, for both judiciary prelims and mains, this section is extremely important. In prelims, you can expect a direct MCQ on the section number or the principle itself. For mains, you can quote this section in your answers to score those extra marks. And for APO exams, you can definitely expect direct, problem-based questions on this, especially in cases dealing with an alibi or illegal possession. So, let's do a very quick revision. What are the 3 key takeaways? First, the provision is Section 109 of the Bharatiya Sakshya Adhiniyam 2023. Second, its core concept is that the person with special knowledge of a fact has the burden to prove it. And third, its importance for both judiciary and APO exams is very, very high. And that's all for our explainer on Section 109. I hope this was absolutely crystal clear. For more judiciary-focused legal content just like this, make sure you stay connected with Ganga Education. Today, we're going to tackle 2 really crucial sections of the Indian Evidence Act 1872. That's Section 110 and Section 111. From a judiciary and APO exams perspective, these 2 are absolutely fundamental, so let's get right into it. So picture this. A person has been missing for years. Now, for all the legal stuff, things like inheritance or insurance claims, does the court consider them alive or are they legally dead? And here's the most important question. Who has the responsibility to prove it? The burden of proof, who's it on? Well, the answers to these very questions are found in Sections 110 and 111. All right, here's a quick look at our roadmap for this session. First, we'll cover Rule 1, which is the presumption of life. Then we'll move on to Rule 2, the presumption of death. After that, we'll dive into the key differences between these 2 sections. We'll also analyze a landmark case, discuss some practical court scenarios, and finish up with some quick revision tips for your exams. Okay, let's start with our very first rule, the presumption of life. You can think of this as the law's default position or its starting point whenever there's a question about whether a person is alive or dead. Now, this rule comes to us from Section 110 of the Indian Evidence Act 1872. The whole section is based on a concept called the presumption of continuity of life. It's a fundamental idea for judiciary and APO exams, so make sure you understand this one clearly. So, what does this actually mean in simple terms? It means that if it's proven that a person was alive at some point within the last 30 years, the law will just assume they're still alive. The crucial point here is that if someone wants to claim that the person is dead, the responsibility, the burden of proof, is entirely on them to prove it. Let's break down the essential ingredients of this section. First, there has to be an actual legal dispute about whether the person is alive or dead. Second, you have to prove that the person was in fact alive within the last 30 years. Third, the law's default assumption will be the presumption of life. And fourth, the burden of proof falls on the party that is claiming the person is dead. See, it's pretty simple and logical when you break it down. So, we have understood the general rule. But what if someone has been missing for a very, very long time? Well, that's where our rule number 2 comes in, the presumption of death. And this is a really important exception to Section 110. This rule is laid out in Section 111 of the Indian Evidence Act. This section deals with those specific situations where a person has been missing for a long time and there's just no information about them. Now, this is where a huge change happens. This means that if you can prove that a person hasn't been heard of for the last 7 years by their close relatives, the people who would naturally have heard from them, then the law will presume that the person is dead. Let's look at the essential ingredients for Section 111. First, there has to be a continuous absence for 7 years, without any communication. Second, this absence must be noticed by natural witnesses, like family members. Third, the law's presumption now switches from life to death. And here's the most important point of all. The burden of proof now shifts to the person who is claiming the individual is still alive. Okay, let's do a direct comparison between these 2 sections. The This is probably the most important part from your exam's point of view. This side-by-side comparison will help you remember these concepts forever. Let's analyze this table. First parameter is the time frame. For Section 110, it's 30 years, and for Section 111, it's 7 years. The second parameter is the presumption. Section 110 has a presumption of life, while Section 111 has a presumption of death. And third, the burden of proof. In Section 110, it's on the person claiming death, but in Section 111, it's on the person claiming life. The difference is crystal clear. You know, for your mains exam, just reading the BEAR Act isn't enough. You absolutely have to know how the courts, especially the Supreme Court, interpret these sections. In this context, the most important case you need to know is LIC of India versus Honorata. This is a landmark judgment that really clarifies the relationship between Section 110 and Section 111. The Supreme Court made two very important things clear in this case. First, that Section 111 acts as an exception to Section 110. After 7 years of absence, the presumption of death kicks in. But, and listen carefully because this is a classic exam trick question, the court also said that Section 111 only presumes if the person is dead. It does not presume the specific date of their death. The exact date of death has to be proven separately with evidence. Okay, let's apply this knowledge. In your mains exam, you'll get problem-based questions, so it's essential to understand how these sections are applied in real-life situations. Let's take a scenario. A woman, A, has a husband who went on a trek 8 years ago and just never came back. So the legal question is, can A remarry? Is her husband legally considered dead? Well, Section 111 clearly applies here because it's been more than 7 years. The law will presume her husband is dead. Now, if someone wants to claim he's still alive, the burden of proving that is on them. That's how this presumption works in civil matters. We're now moving towards the end of our explainer, so let's look at some focused exam tips and quick revision points that are going to help you in both your prelims and mains. Make a note of these points. For prelims, you'll see direct questions on the time frame, that's 30 versus 7 years, and on the burden of proof. For mains, expect problem-based questions related to inheritance, insurance, or even bigamy. You might also get a short note on the difference between presumption of life and presumption of death. And remember, never forget to mention the LIC versus Honorata case. Let's do one last quick revision. Remember 3 main things. Section 110 means presumption of life, based on 30 years. Section 111 means presumption of death, based on 7 years of absence. And the most crucial part, the shift in the burden of proof in Section 111. These sections are extremely important for your exams, so always keep their application in mind. For more judiciary, APO, and long-SAM-focused legal content, stay connected with Ganga Education.
Today, we're going to dive into 2 really important sections from the Bharatiya Sakshya Adhiniyam 2023, Section 112 and Section 113. Now, these sections are absolutely fundamental for understanding the whole concept of burden of proof, which makes them critical for anyone preparing for judiciary and APO exams. So let's get right into it.
So, here's our game plan. We'll start by understanding the power of presumption. It's the foundation for everything else. Then, we'll see how it works in Section 112, which deals with relationships. After that, we'll look at Section 113, which is all about ownership. And finally, we'll wrap it all up with some sharp exam focus and a quick revision to make sure these concepts stick.
Okay, let's kick things off with our first topic, the power of presumption. What is it really? Well, you can think of it as the court's default setting. When the facts of a case aren't totally clear, the court needs a logical place to start, a kind of assumption to get the ball rolling. And that initial assumption is what we call a presumption.
So a legal presumption is a pretty powerful tool. It's a rule that lets the court say, okay, we're going to assume this fact is true unless and until someone proves it's not. This is absolutely crucial because it helps decide who has the burden of proof, who has the job of bringing the evidence. And Sections 112 and 113 are just fantastic examples of this principle in action.
Right. With that foundation in place, let's jump into our first key section, Section 112. This section is all about the presumption of continuity when it comes to certain legal relationships. What that means is, once a relationship is shown to exist, the law just assumes it's still going on, unless someone can prove that it has ended.
And here it is, the formal text of Section 112. For your exams, it's really important to identify this section correctly. You'll notice it's very specific. It applies to relationships like partnerships, landlord and tenant, and principal and agent. These are all relationships that depend on an ongoing understanding between the parties.
The BEAR Act says, when the question is whether persons are partners, landlord and tenant, or principal and agent, and it has been shown that they have been acting as such, the burden of proving that they do not stand in those relationships is on the person who affirms it. Phew! So what does all that legal language actually mean? Well, in simple terms, it means if you prove that A and B were landlord and tenant, the law presumes they still are. If B suddenly claims, hey, that relationship is over, then it's on B to prove it.
This section really boils down to 4 essential ingredients. First, there has to be a dispute about one of those specific relationships. Second, you have to show proof that the parties were in fact acting like partners or like a landlord and tenant. Third, the law then kicks in with a presumption of continuity. And that leads to the 4th and most important part. The burden of proof shifts to the person who is now trying to deny that relationship.
Let's make this crystal clear with a practical example you might see in an exam. So imagine person A proves that person B was their tenant. How? By showing rent receipts. Simple enough. At that exact moment, the burden of proof flips. It's no longer on A, it's on B. Now, if B claims the tenancy ended last month, it's B's job to prove it. He'd have to show some solid evidence, maybe a termination notice.
And this isn't just theory, by the way. The courts have upheld this principle. A landmark case here is Krishna Mohan Kool versus Pratima Maiti. The court held very clearly that once you establish a tenancy, the burden to prove it has ended falls squarely on the person who is denying that it's still going on. This is a very important case law to remember for your mains answers.
You know, this whole idea is beautifully summed up in a legal maxim. Actor incumbit onus probandi. It's a fancy way of saying that the burden of proof is on the person who makes a claim. Section 112 is a clever application of this because the burden shifts to the other person after that initial fact, the existence of the relationship, is proven.
Okay, we've got a good handle on Section 112 and relationships. Now let's shift gears and look at Section 113. It applies a very similar kind of logic, a similar kind of presumption, but this time to the concept of ownership, and it all starts with possession.
So here we have it. Section 113 of the Bharatiya Sakshya Adhiniyam 2023. This one is built on a very simple but profound idea, the connection between possessing something and owning it.
The BEAR Act reads, when the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. What does that really mean? It's quite straightforward, actually. If you are in possession of something, the law's first guess, its presumption, is that you're the owner. And just like with Section 112, we can break this one down into 4 essential parts. First, the case has to be about who the real owner is. Second, it has to be proven that someone is currently in possession of that thing. Third, the law then steps in and creates a presumption of ownership. And finally, this puts the burden on the challenger. Anyone who wants to dispute that ownership has to be the one to prove their own case.
Let's put this into a real-world scenario. Imagine A is living on a piece of land, farming it, and is clearly in possession. Then B comes along and files a case claiming, hey, that's my land. In this situation, the legal burden is entirely on B. B has to come to court with superior evidence, something like a valid title deed, to prove his ownership and overturn the presumption that favors A.
And again, the Supreme Court has weighed in on this. In the famous case of Nair Service Society Limited versus K.C. Alexander, the court held that possession is a good title against the whole world, except for the true owner. This is huge. It means that possession itself is a right that the law protects.
And just like before, there's a neat legal maxim that captures the entire spirit of Section 113. It's possessio prima facie ostendit dominium. This simply translates to possession is prima facie evidence of ownership. If you can remember this maxim, you can remember the whole point of this section.
All right, fantastic. We've gone through both sections in detail. Now let's pull it all together and focus on exactly what you need to remember for your judiciary and APO exams. Now here is a crucial tip for your exams. The main takeaway is that both Section 112 and 113 are about presumptions that shift the burden of proof. This is a very popular topic for examiners. In your prelims, you can expect direct questions asking about the section number. And in your mains, you're very likely to see problem-based questions based on these principles, so you have to prepare them thoroughly.
To really lock this in, let's do a quick side-by-side revision. For Section 112, the core concept is continuity of relationship.
The presumption is that a proven relationship continues, and the burden shifts to whoever claims it is ended. For Section 113, the core concept is possession implies ownership. The presumption is that the person in possession is the owner, and the burden shifts to anyone who challenges that ownership. The most effective way to master these sections is to remember these three things for each. What's the core concept, what is the legal presumption, and who does the burden of proof shift to? If you can remember that, you're set. That wraps up our detailed look at Sections 112 and 113. For more exam-focused legal content like this, stay connected with Ganga Education.
Today, we're going to break down a very important provision, Section 114 of the Indian Evidence Act 1872. This one deals with the concept of good faith, especially in relationships of active confidence. Now, if you're preparing for the judiciary or APO exams, you'll want to pay close attention, because understanding this section is absolutely crucial. So, what's our game plan for today? First, we'll dive into the core principle of Section 114. Then, we'll break it down into its essential ingredients. After that, we'll see how it works in the real world with some practical examples and case law. And finally, we'll wrap up with the key takeaways that you absolutely need for your exams. All right, let's get started with the core idea. I want you to think of Section 114 as a kind of legal shield. It's specifically designed to protect someone who might be in a more vulnerable position in a relationship that's built on trust. It's there to make sure that this trust isn't taken advantage of. So the formal title of the section is about the proof of good faith in transactions where one party is in relation of active confidence. Now that key phrase, active confidence, is what this is all about. We're talking about relationships where one person naturally puts a whole lot of trust in another. Think about a lawyer and their client, a doctor and their patient, or even a parent and a child. Okay, that's the language straight from the BEAR Act. So what does it actually mean in simple terms? Well, it means that if there's any question about the fairness of a deal between two people in one of these trust-based relationships, the law flips the script. The weaker party doesn't have to prove they were cheated. Instead, the burden of proof, the responsibility, is completely on the more powerful party to prove that the deal was fair and done in good faith. Okay, so to really master this section for your exams, we have to break it down into its key ingredients. These are the fundamental building blocks of the entire principle, so let's get into it. For this section to even come into play, 4 essential things need to exist. First, there must be a relationship of active confidence. Second, there has to be a transaction, some kind of deal between these parties. Third, the good faith or fairness of that deal has to be challenged. And once those 3 things are established, the 4th and most critical element kicks in. The burden of proof automatically shifts to the person in the dominant position to prove everything was above board. And this flowchart shows you exactly how the court thinks about these cases. It's a very logical step-by-step process. The court first checks if there's that special relationship. If yes, and a transaction is questioned, boom, the burden of proof immediately shifts. It's a clear sequence of events. Okay, theory is one thing, but how does this law actually work in the real world? Seeing how it's applied in practical scenarios and landmark cases is absolutely essential if you want to score well in your mains exam. Let's take a classic example that you'll see often. Imagine an advocate buys a piece of property from his own client. Sometime later, the client starts to feel that the price they got was way too low. In this situation, the court won't ask the client to prove they were tricked. No. Because of that special advocate-client relationship, Section 114 puts the entire responsibility on the advocate to prove that the price was fair, that the client's consent was completely free, and that he didn't use his position to gain an unfair advantage. And this isn't just a hypothetical idea. This very principle was powerfully established in the landmark case of Krishna Mohan Kool versus Pradima Mighty. The court held that in any fiduciary relationship, which is just a fancy term for a relationship based on trust, the person in the dominant position has to prove that the transaction was righteous and that absolutely no undue influence was used. You'll definitely want to remember to cite this case in your answers. You know, the entire spirit of Section 114 is beautifully captured by this legal maxim, fraus et jus nunquam cohabitant. It simply means that fraud and justice never dwell together. The law will just not stand by and let a relationship of trust be used as a disguise for fraud. This maxim really gives you the philosophical foundation for the whole section. All right, let's shift gears and get laser focused on what you really need for your preparation. What are the absolute key takeaways for your judiciary and APO exams? Let's get right into these clear, actionable points. So here's a question that often trips students up. Is there any kind of punishment mentioned under Section 114? What do you think? And the answer is no. And this is a super important clarification. Section 114 is what we call a rule of evidence. That means it's a procedural rule. It's all about telling the court who has the responsibility to prove a fact. It doesn't actually define a crime or prescribe any punishment for it. Now for another critical update for your upcoming exams. This very important principle has been kept in the new criminal laws. So what was Section 114 in the Indian Evidence Act is now Section 112 in the Bharatiya Sakshya Adhiniyam of 2023. The principle is exactly the same, but you absolutely have to remember the new section number. So here's your clear exam strategy. For your prelims, you need to know the section numbers, both the old and the new, and the core concept of the burden of proof. But for your mains exam, you've got to go deeper. You need to write a detailed answer explaining all the essential ingredients. Use an illustration, like the one we discussed with the advocate and client. And of course, you must cite the Krishna Mohan Cole case. To wrap it all up, let's do a quick revision. If you remember just 3 things, let it be these. First, the section numbers. 114 of the IEA, which is now Section 112 of the BSA. Second, the core concept. The burden of proof is on the party who is in a position of active confidence. And third, its exam importance is very, very high for both prelims and mains. And there you have it, a detailed breakdown of this powerful section that really champions fairness and justice. For more high-quality, exam-focused legal content like this, make sure you stay connected with Ganga Education.
Today, we are going to tackle an absolutely crucial section from the new Bharatiya Sakshya Adhiniyam 2023, that's Section 115. Now, this section deals with the presumption as to certain offenses. For all you judiciary and APO aspirants, this is a real game changer. So let's dive in and master it step by step.
So let's start with a really thought-provoking question. When can a court actually presume that you're guilty right from the get-go? We all know that the golden rule of criminal law is innocent until proven guilty. But, Section 115, in some very specific and exceptional cases, completely flips this rule on its head. So how does it do that? Let's find out. For this session, we have a very clear roadmap. First, we'll cover the basics of Section 115. Then we're going to decode the presumption, basically how it works. After that, we'll look at a practical example, touch upon some key judicial principles, and finally, and this is the most important part, we'll focus on exactly what you need to know for your exams. All right, so first things first, let's really build a strong foundation. What exactly is this law, and what's its fundamental purpose? Let's get right to the core of this provision. So here it is, Section 115 of the Bharatiya Sakshya Adhiniyam 2023. You see, its main purpose is to create a special rule of presumption for some very serious offenses that happen in what are called disturbed areas. The whole idea is to help maintain public order and security in those sensitive places. Now pay close attention to this line right from the BEAR Act. In simple terms, what it means is that if the prosecution can prove certain foundational facts, the court will then assume that the accused is the one who committed the offense. And that right there is a massive shift. The burden of proof literally moves from the prosecution over to the accused. It's now their job to prove they're innocent. To really understand this section, you need to focus on these keywords. First up is disturbed area. This isn't just any area. It has to be legally declared as one. Second, the use of firearms or explosives against armed forces. Third, presumption, which is the court's initial assumption of guilt. And finally, and this is absolutely critical, the presumption is rebuttable. This means the accused gets a full and fair chance to present evidence and prove their innocence. Okay, so we've got the key ingredients. Now let's see how a court actually puts all these pieces together. Let's decode the logical sequence that the court follows when it applies this very powerful presumption. The court follows a very clear, step-by-step process. First, it asks, was the location a legally declared disturbed area? Step 2, has the prosecution proved beyond a reasonable doubt that the accused person was present at that scene? And step 3, were firearms or explosives actually used against security forces from that location? Now, if and only if the answer to all 3 questions is a resounding yes, that's when the court will apply the presumption under Section 115, and the burden of proof shifts to the accused. All this legal theory is great, but let's make it real. Let's walk through a practical courtroom example to make this concept absolutely crystal clear. Okay, imagine this scenario. An area in a city has been officially declared a disturbed area. A large, violent mob attacks the police with weapons. Now, the prosecution manages to prove that a person, let's call him A, was right there, present in that mob. Under Section 115, the court will now presume that A was an active participant in that unlawful attack. The responsibility is now on A to bring evidence to prove that he was just an innocent bystander who got caught in the wrong place at the wrong time. Now, it's important to understand that this section isn't just some arbitrary rule that came out of nowhere. It's actually grounded in well-established legal principles, and it's been carefully examined by the Supreme Court in landmark judgments that give it the necessary context. This whole principle can be understood through a legal maxim, presumptio juris tantum. It's a Latin phrase, and it simply means a rebuttable presumption of law. This is the exact same concept that's captured in Section 115 by the words unless the contrary is shown. So the presumption stands until and unless someone proves it wrong. Landmark case laws really show us how courts have interpreted these kinds of provisions. In Kartar Singh v. State of Punjab, the Supreme Court upheld the constitutional validity of such presumptions in special anti-terrorism laws like TADA, saying they were necessary. But, and this is a big but, in State of Maharashtra v. Mohammed Yaqub, the court also established a critical safeguard. It stressed that before any such presumption can be applied, the prosecution must solidly establish the foundational facts first. All right, let's switch gears now and get to the most important part of our session, specifically for your judiciary and APO exams. Let's really focus on what you absolutely need to remember from this section. So, in the past, provisions like this were found in special acts like TADA. But the big change now is that this concept has been taken from those special laws and codified directly into the country's primary evidence law, the Bharatiya Sakshya Adhiniyam, as Section 115. This is a very significant change, and it's really important to note for your exams. Now, here's something you must always remember. Section 115 itself does not prescribe any punishment. It's a rule of evidence. This presumption applies to offenses like rioting or unlawful assembly under Sections 147, 148, 149, and 150 of the BNS. The actual punishment comes from those sections. Section 115 is just the evidentiary tool that helps prove them. So how do you prepare this for your exams? Well, for the prelims, you can definitely expect a direct question on the section number or its core concept. For the mains, you might get a short note on rebuttable presumption, or even a problem-based question involving a riot in a disturbed area. And if you make it to the interview, be prepared to discuss the delicate balance between public security and individual rights under this section. Okay, let's do a super quick revision. Just remember these three things. First, the section number 115 of BSA 2023. Second, the core concept. It's a rebuttable presumption of guilt. And third, the key principle. It shifts the evidential burden to the accused. And remember, its importance for your exams is very, very high. So that was our detailed analysis of Section 115. It's a section that strikes a very delicate and often debated balance between public security and individual rights. I really hope its core principles and its importance for your exams are now perfectly clear. For more judiciary, APO, and law exam-focused legal content, please stay connected with Gunga Education.
So, how exactly does the law decide who a child's father is when there's a dispute? It's a really fascinating question. Today, we're going to dive into a super important topic for all you judiciary and APO aspirants, Section 114 of the new Bharatiya Sakshya Adhiniyam 2023. This section deals with the powerful legal idea of conclusive proof of legitimacy.
So here's how we're going to tackle this. First, we'll look at the basic rule of Section 114. Then, we'll break it down into its key parts and really understand what conclusive proof means. After that, we'll check out how this works in some major court cases, and, of course, we'll wrap up with some quick revision tips to make sure you're ready for your exams.
All right, let's jump right in. We're starting with the absolute foundation, the core principle of Section 114.
आज हम डिस्कस करेंगे Section 114 of the Bharatiya Sakshya Adhiniyam 2023. Now this section is all about what we call conclusive proof of legitimacy. What that really means is that the law makes a very strong assumption about a child's parentage if that child is born during a valid marriage.
Okay, that sounds a bit heavy, right? So what does it actually mean? सिंपल लैंग्वेज में समझें तो इसका मतलब है कि अगर कोई बच्चा एक वैलिड लीगल मैरिज के टाइम पैदा होता है तो लॉ ऑटोमेटिकली अज्यूम्स विदाउट अ डाउट दैट ही इज द लेजिटिमेट चाइल्ड ऑफ द हस्बैंड. This is an incredibly powerful rule in law.
So, now that we've got the basic idea, let's take it apart.
We're going to deconstruct this section into its essential ingredients to see exactly how it's built.
First up, and this is the most important starting point, is a valid marriage. इसका मतलब है कि at the time the child could have been conceived, there must be a legally recognized marriage between the mother and the man. If there's no valid marriage, this whole section just doesn't apply. Simple as that.
Okay, second keyword, birth during continuance. Now, this has two scenarios. The first one is pretty straightforward. The child is born while the marriage is still active. The second one is a bit more specific. The child is born within 280 days after the marriage ends, say through a divorce. But, and this is a big but, there's a condition. The mother has to have remained unmarried during those 280 days. And our third key term is non-access. You have to pay close attention here because this is the only exception to this very strict rule. Non-access isn't just about saying they didn't have a relationship. It means you have to prove that the husband and wife had absolutely zero opportunity for any physical intimacy around the time of conception. So, how does a court actually use this section? Well, it follows a very clear logical path. Step 1. Establish a valid marriage. Step 2. Confirm the child's birth timing fits the criteria. As soon as those two things are proven, bam, the law automatically presumes the child is legitimate. The only way to challenge it is for the other party to then prove that one exception, non-access. Now, let's talk about the real power behind Section 114. This is where we get into the conclusive proof doctrine, and believe me, it is a real game changer in the eyes of the law.
So here's the central conflict of the section, laid out simply. On one hand, you have conclusive proof. The law treats the child's legitimacy as a settled fact. Why? Mainly to protect the child's welfare and social standing. It's so strong that you generally can't challenge it with things like a DNA test. But on the other hand, you have that single, tiny window, the exception of non-access, and the burden to prove it is incredibly high.
You know, this entire legal idea is captured perfectly in a famous Latin maxim, peccare est quem nuptia demonstrant. It literally means, the father is he whom the marriage indicates. This maxim is really the philosophical heart of Section 114. Okay, the theory is important, but how does this actually work in a real courtroom? Let's look at how the Supreme Court has interpreted this section. This is absolutely crucial, especially for your mains exam.
The first landmark case we have to discuss is Gautam Kundu versus the state of West Bengal. This case is a huge deal because it addresses that classic clash, the strong legal presumption versus modern science, specifically DNA testing.
So what did the Supreme Court decide? It held that courts can't just order DNA tests casually in these matters. The law places the presumption of legitimacy above all else to protect the child from social stigma. A DNA test can only be ordered in very rare and exceptional circumstances, not just to satisfy someone's curiosity.
All right, our second key case is Kamti Devi versus Poshiram. This judgment really doubles down on just how high the standard of proof is when you're trying to claim non-access.
So listen closely, this is the main takeaway. The Supreme Court made it crystal clear. To prove non-access, you can't just raise a little doubt. You need strong, clear, and conclusive evidence. The standard is way higher than just a balance of probabilities. You have to prove it beyond a reasonable doubt. Okay, let's put it all together. Time to focus on exactly what you need to remember and nail down for your judiciary and APO exams. First things first, and this is a crucial update you cannot miss. This same rule used to be Section 112 of the old Indian Evidence Act from 1872. Now, under the new Bharatiya Sakshya Adhiniyam of 2023, it is Section 114. The rule itself is the same, but the section number has changed. Remember that. Now for some quick exam tips. For your prelims, expect direct questions on the new section number 114 BSA and the term conclusive proof. For mains, be ready for a short note or a problem-based question. Always remember to mention the only exception, which is non-access. And if you can, quote the Latin maxim, and definitely cite the Gautam Kundu case when talking about DNA. Okay, for a last-minute revision, just lock these 4 points into your brain. 1. The section is 114 of the BSA. 2. The core concept is conclusive proof of legitimacy. 3. The only exception is proving non-access. And 4. The key case is Gautam Kundu. If you've got that down, you're in great shape for any question on this topic.
And that wraps up our deep dive into this very important section. For more exam-focused legal content just like this, make sure you stay connected with us here at Ganga Education.
Today, we're going to break down two really critical sections of the new Bharatiya Sakshya Adhiniyam 2023. We'll be focusing on Section 117 and Section 118. Now, if you're preparing for your judiciary or APO exams, you'll absolutely want to pay close attention to this. So let's kick things off with a fundamental question, one that every law student thinks about. Under what circumstances can a court actually presume someone is guilty, even when there's no direct, concrete proof? Well, the answer to that lies in a powerful legal concept known as presumptions. Our legal system uses this tool to help find the truth, and it's especially important in very sensitive cases, like those involving cruelty against married women. And that's exactly what Sections 117 and 118 are for. They are designed to empower our judiciary, to give them the tools to deliver justice in difficult situations where direct evidence might be scarce or even hidden. So with that foundation laid, let's dive into the first section. All right, first up we have Section 117. This section deals specifically with the presumption related to the abetment of suicide. You see, this is a very important protective provision. It was created to address the serious and tragic social issue of cruelty that can occur within a matrimonial home. For court to apply this section, a specific set of circumstances or ingredients must be met. A married woman must have committed suicide, it must have occurred within 7 years of the marriage, and there must be evidence that she was subjected to cruelty by her husband or his relatives. If these three things are proven, the court may presume that the suicide was abetted. The key word here is may. This tells us that the presumption is discretionary, not mandatory. So you can think of it as a logical path. If the prosecution successfully establishes those first three conditions, it essentially opens a door. It's then up to the court to use its discretion and decide whether or not to walk through that door and draw the presumption. The court will consider all the other evidence. It's never an automatic decision. Now for your mains answers. Quoting these landmark cases is a fantastic way to add weight. In Gorbachan Singh versus Satpal Singh, the Supreme Court made it clear that there has to be a close causal link between the cruelty and the suicide. And the Ramesh Kumar case really cemented the idea that may presume means just that. It gives the court a choice, it's not a command. Okay, now let's turn our attention to Section 118. This one deals with dowry death, and as you're about to see, it is a much more stringent and forceful provision than the one we just discussed. This provision was designed from the ground up to reflect just how serious the crime of dowry-related harassment is. Because of that, the nature of the presumption here is fundamentally different. Pay very close attention to the key words here. The time frame isn't a fixed period, like 7 years. It's soon before death, which implies a direct, recent connection. But the most important element, the real game changer, is the phrase shall presume. This removes all discretion from the court. This flowchart really highlights the critical difference. If the prosecution proves those foundational facts, a suspicious death, dowry-related cruelty, and that the cruelty happened soon before the death, then the court is legally bound to presume it was a dowry death. This immediately shifts the burden of proof onto the accused to prove their innocence. And these landmark judgments reinforce that mandatory nature. In Kansraj versus State of Punjab, the Supreme Court explained that soon before death requires a proximate and live link between the two events. Then, the Satbir Singh case affirmed that once the ingredients are proven, the presumption under shall presume is absolute and mandatory. The court must apply it. So, now that we've looked at them both, let's put them side by side to really sharpen our understanding. From an exam point of view, knowing these distinctions inside and out is absolutely vital. This table perfectly summarizes the four major differences. The most obvious is the shift from a discretionary may presume to a mandatory shall presume. This shows just how seriously the legislature treats dowry deaths. Also notice that the cruelty in Section 118 must be linked to a dowry demand, unlike the more general cruelty in Section 117. These are the kinds of nuanced points that examiners are looking for. To be perfectly clear on the legal meaning, may presume gives the court a choice. It can either accept a fact as proven or it can call for more proof. Shall presume, on the other hand, is a legal directive. The court must consider the fact as proven until the other party manages to disprove it. This makes shall presume a much, much stronger legal tool. Okay, let's wrap this up by focusing on how this information is likely to appear in your judiciary and APO exams. For your prelims, you should expect direct questions. They might ask for the section numbers or quiz you on the difference between may presume and shall presume. For the mains, however, you need to be ready for more complex questions. You could be asked to write a short note on Section 118, or you might face a problem-based question where you have to apply these principles to a fictional case scenario. So for a quick revision, just lock this into your memory. Section 117 is about abetment of suicide and uses the discretionary may presume. Section 118 is about dowry death and uses the mandatory shall presume. This fundamental difference in the nature of the presumption is the single most important thing to take away. And this brings us to a final thought for you to consider. How does a simple change of one word in the law, from may to shall, reflect society's evolving and strengthening stance against a heinous crime like dowry death? It's a powerful reminder of how language in law can truly shape justice. For more legal explainers focused on your judiciary and APO exams, please stay connected with us here at Ganga Education. So let's start with a really interesting question. How can a court believe a fact is true without any direct proof? It sounds a bit like magic, right? Well, it's not. It's a legal power, and we're going to break it down today by looking at Section 119 of the Indian Evidence Act 1872. And let me tell you, for anyone preparing for the judiciary and APO exams, this section is absolutely crucial. So here's our roadmap for this session. We'll start with the basics of Section 119, decode the legal language, understand the logic behind it, and then see it in action with some real cases. Finally, we'll wrap up with key illustrations and what you absolutely need to know for your exams. All right, let's dive right in. The core idea of Section 119 is what we call the power of reasonable presumption. But what does that even mean in simple terms? So what exactly is this power? It's called a discretionary presumption. The easiest way to think about it is, well, it's like the court's power to use common sense. It allows a judge to look at the facts they do have, think about how the world usually works, and then connect the dots to reach a logical conclusion. And the amazing part? They can do this even when there's no direct smoking gun evidence. Okay, so now that we've got the basic concept down, let's see what the law books actually say. It's time to decode the exact legal wording from the BEAR Act. The Act says the court may presume the existence of a fact if it seems likely, based on the common course of natural events, human behavior, or business dealings. Now, I want you to focus on those two little words, may presume. What do they tell us? It's a huge clue. It tells us this isn't a command, it's not a must, it's an option, a choice that the court has. This table really breaks it all down for us. Look at that first keyword, may presume. As we just said, this means the court has discretion. It's not a hard and fast rule. The second point, the basis, tells us the court can't just guess. The presumption has to be grounded in logic, how things normally happen in nature, in human conduct, or in business. And the last one, rebuttable, is incredibly important. This means the presumption isn't the final word. The other side can always come in with evidence to prove it wrong. So how does a court actually apply this logic in practice? Let's get inside a judge's head and look at the thought process. It's basically a simple four-step process. As you can see, it all starts with step 1. A fact is presented in court. Then, in step 2, the court links that fact to a common pattern of life. In step 3, the court uses its discretion and says, okay, based on this, I'm going to presume this other fact is also true. And finally, step 4. That presumption stands strong unless someone comes along and knocks it down with counter-evidence. Simple, right? This whole idea is built on a really powerful legal principle, summed up in this Latin maxim, omnia presumuntur rite esse acta. It might be a mouthful, but the meaning is actually pretty simple and profound. All official acts are presumed to have been done properly. Think about it. This is a fundamental assumption that keeps our entire legal and administrative system running smoothly. We trust that things are being done the right way. All right, enough theory. Let's take this from the classroom to the courtroom and see how Section 119 actually works in practice, using some real examples and case law. Let's take a classic example. Imagine a laptop is stolen. The very next day, a person, let's call him A, is found with that exact same laptop. When the police ask him, hey, where'd you get this? He can't give a straight answer. Now, put yourself in the judge's shoes. What would you start to think? This exact scenario is one of the key illustrations in the Act itself, and we'll break it down in just a bit. Now, to see how courts handle situations where evidence seems to be missing, the case of Tommaso Bruno versus the state of Uttar Pradesh is a super important landmark. In this major judgment, the court laid down a powerful rule. As you can see, the issue was about withholding evidence. The court held that if a party deliberately hides the best piece of evidence, the judge is allowed to draw an adverse inference. That's a fancy way of saying the judge can presume that the hidden evidence would have actually hurt that party's case. It's a penalty for not playing fair. Another key case that builds on this very principle is Ishwar Bai C. Patel versus Harihar Behera. This case reinforces two key ideas we've already talked about. First, it recognizes that presumption about official acts being done properly. And second, it highlights that a person's conduct, how they behave, can be powerful evidence in itself, something from which a court can draw logical conclusions.
Okay, everyone listen up, especially those of you preparing for exams. This next part is pure gold. The illustrations given in the BEAR Act for Section 119 are asked all the time, so let's break down the most important ones that you absolutely have to know.
This slide summarizes the key presumptions you need to memorize. Take a look at point A. That's our stolen goods example. Possession can lead to a presumption of theft. Point B is a rule of caution. You can't just trust an accomplice's testimony without some backup. Points E and G directly reflect the case law we just discussed. And finally, I gives a great business example. If a borrower has the loan document back, the court can presume the loan has been paid off. Finally, let's consolidate exactly what you need to remember about this section for your judiciary and APO exams. So, how should you prepare? It's really a two-part strategy. For your prelims, focus on the illustrations, expect direct multiple-choice questions on them. But for mains, you've got to go deeper. You'll likely get problem-based questions where you'll have to apply these principles. And the number one concept you must master is the meaning of may presume, the fact that it is always discretionary. To wrap everything up, here is your final revision checklist. 1. The section number is 119. 2. The court's concept is the court's discretionary and rebuttable power. And 3. Its exam importance is very high, especially those illustrations. Memorize these 3 points. And that was our deep dive into Section 119. Master these principles and you'll be able to answer any question on this topic with confidence. For more exam-focused legal breakdowns, make sure you stay connected with Ganga Education.
Today, we're diving deep into Section 120 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is absolutely crucial for your judiciary and APO exam preparation because it deals with a very important rule of evidence about consent in rape cases.
So here's our roadmap for today. We'll start with the core concept of Section 120, and then we'll break down its key ingredients. After that, we'll look at its structure with a practical example, touch upon some important case laws, understand its real power in court, and finally, we'll wrap up with a sharp focus on what you need for your exams.
At its very heart, Section 120 is all about a statutory presumption. So what does that mean? It means the law itself creates a legal assumption that works in favor of the victim in rape prosecutions. To really get this, let's look at the exact wording from the BEAR Act.
The language here is incredibly direct and very powerful. You see, it sets up 2 simple conditions. First, the act of sexual intercourse has to be proven, and second, the woman has to state in her court evidence that she did not consent. If both of these are met, the court shall presume there was no consent. Notice the word shall. This isn't a choice for the judge, it's a direct command from the law.
Okay, to truly understand just how significant this section is, we need to deconstruct it. We're going to break it down into its essential elements, or what we often call ingredients in legal terms. Getting these ingredients right is the key to applying this section correctly.
So this table lays it out perfectly. There are 4 key ingredients. First, the case has to be a prosecution for rape. Second, and this is a precondition, sexual intercourse must be proven as a fact. Third, the victim herself has to state in court that she did not give her consent. And finally, the most critical part, the mandatory presumption. That phrase, shall presume, is everything. It leaves 0 room for the judge's discretion. It's a command.
So, how do all these ingredients actually work together in a real courtroom? Well, they create a very logical sequence that the court has to follow. Let's move to the next slide and see exactly how this unfolds step by step. This flowchart shows the clear 4-step process. Step 1, the prosecution proves that intercourse happened. Step 2, the victim testifies that she did not consent. The moment these 2 things are on record, we hit Step 3. The court automatically presumes there was no consent. And this triggers the biggest consequence of all. In Step 4, the burden of proof completely shifts to the accused to now prove that there was valid consent.
Let's make this even clearer with a practical example. Just imagine a courtroom scene.
The prosecution presents medical reports that prove intercourse occurred. Next, the victim gets in the witness box and states firmly, "I did not consent." That's it. Based on Section 120, the judge instantly has to presume there was no consent. The entire focus of the trial now flips to the defense lawyer, who has the job of bringing forward strong, credible evidence to prove that consent was, in fact, given.
Now, any law on paper is really shaped by how our higher courts interpret it, so it's super important to look at the landmark judgments and the legal principles that guide how Section 120 is actually applied in the real world.
In the landmark case of State of Punjab versus Gurmeet Singh, the Supreme Court laid down a fundamental principle. The court held that a rape victim's testimony has immense value and must be treated with serious consideration. It shouldn't be doubted lightly. This judgment perfectly reinforces the spirit behind Section 120, which is all about giving legal weight and credibility to the victim's statement.
Now, you might be wondering, while Section 120 is very victim-centric, what about fairness to the accused? Well, that's where the principle of natural justice comes in, through the legal maxim audi alteram partem, which simply means listen to the other side. This principle ensures that even with the presumption against him, the accused gets a full and fair chance to present his evidence, like messages, witnesses, or other circumstances to prove that consent was actually there. This right to challenge the presumption is what ensures a fair trial.
All right, let's zoom in on the evidential value of this section. Why is it considered such a powerful tool in the law of evidence, specifically for rape prosecutions?
So, to sum up its power, first, the presumption is mandatory, not optional. This, in turn, significantly strengthens the victim's testimony. And that leads to the massive shift in the burden of proof. As a result, it reduces the hurdles for the prosecution. But just as importantly, it helps protect the victim from grueling cross-examinations that are designed to attack her character, keeping the legal focus right where it should be, on the accused's duty to prove consent.
Okay, for all of you aspiring to crack the judiciary and APO exams, this is where you need to really listen closely. This is a very high-yield topic, and you can definitely expect questions from it.
For your prelims, watch out for direct questions about the nature of this presumption. They love to create confusion between shall presume and may presume. Just remember, it is always shall presume. It's mandatory. Now, for your mains exam, you should be ready for a problem-based question. They'll give you a factual scenario, and you'll have to apply Section 120 and explain where the burden of proof lies.
All right, for a final quick revision, let's lock in these key points. The provision is Section 120 of the BNS. Its core concept is the mandatory presumption of absent consent. Its key principle is the shifting of the burden of proof to the accused. And its exam importance is very, very high for both prelims and mains.
For more judiciary, APO, and other law exam-focused legal content, make sure you stay connected with us here at Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share, and subscribe to Ganga Education. Keep learning, keep growing, and stay connected for more law lectures.